How's it going, folks? I hope everybody's doing good. Oh my goodness. Um, yeah, I'm sure most of you guys are already caught up on what's going on here today, but I'm getting uh a late I don't want to say a late start, but definitely I'm late to the game here. I'm late to the party. So I'm just gonna go over what everybody already watched, um, and get my take on it. And I figured I would just go live and do that. And I got a few new motions in that I'm gonna go over as well. Uh and yeah, like I keep seeing that. A lot of people getting a lot of giving a lot of approval to this judge sis something. I'm not sure what his name is, um but yeah, let's excuse me. Let's see something real quick. Sisitsky. Okay. All right. Sisitsky. I love it. I love it. Hold on here. Let me see what we got. I'm just looking at I'm looking at I'm looking at some tweets here. Here's one. Wendy Murphy wrote, somebody screenshot this, and Wendy Murphy wrote, public should understand that defense attorneys pay bloggers and PR firms to elevate nonsensical defense theories. Uneducated and gullible people get swept up in silliness. The same people who think JFK Jr. is still alive think cops killed O'Keefe and conspired to cover up of the murder. Never once have I ever, just for the record, Wendy Murphy, I have never ever suspected of JFK Jr. still being alive. Ever. Like, I'm not even on board with the whole JFK assassination conspiracy theories. Like, I'm not on board with Oliver Stone. You know what I mean? I'm not on board with Oliver Stone necessarily. I still think that there's quite the possibility that it was Lee Harvey Oswald. But see, here's the thing: is I haven't really looked into it that deep. The only thing I really know about is the movie, you know. So, but no, don't lump me in with those kind of people because I don't fucking like I'm just looking at the evidence. I'm using common sense here. And you're out here talking about JFK Jr. David Yannetti responds to this. The cerebral ninja responds and says, I am disappointed in you as a former colleague. We have not paid anyone a dime, nor did we tip off Turtleboy to report on this case. He found the story completely on his own, reading our public filings. Also, your theory of the case is nonsense. It is clear you have done no homework and you are just spouting off without understanding the evidence. Shame on you, Wendy. Way to go, David Yannetti, bro. Oh my God, dude. Like, my man. Awesome. Hold on, man. Now, what is going on?
Oh, here we go.
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. Dad, 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 dad. I think we got a super dad.
How dare you?
I wonder if that's gonna make Grant upset, bro. Like, I wonder if that's like wrong side of the blue wall. Thank you so much. Where can I download the free Karen Reed metal song in your intro? I wouldn't call that metal, but I'm just being a music snob right now. But in my description, there should be, unless I accidentally deleted it, but there should be, I normally have it there. Oh, I did delete it. Fuck. Hold on a second. Oh, why can't I find it now? God, that sucks. Sorry, because I really want to help promote that, and I don't know the link. So if anybody has the link to Chris Loring's video on YouTube, I'm going to try something else here. Yeah, see, it's a Hard Rock Life's thing is here. I mean, I'm going to go ahead and share that. Make sure to check out Hard Rock Life's podcast with me. And you can maybe he has the link in the description. I can check. Hopefully. Yes, here we go. I got it. All right, look at that. Okay, so here is the link to the song. All right. Here's the link to the song. And there you go. And let's see, Kyle Cowden, thank you so much. It occurred to me I should try to give expert testimony. After all, I spent a day in the MEs during rotations with Dallas. Okay, thank you so much. Appreciate it, buddy. So yeah, good on David Yannetti for that. That was yesterday that he did that. And I love that because he's like, dude, you know, like as a lawyer, how the fuck can you sit up there and spew that nonsense? You know what I mean? Let's see here. Now, there was something else that I checked here. So Krusty Panties posted something that I thought was funny. Let's see. She's like, I'm fine with the amount of vitriol I get. All the abusive comments and communications constantly being maligned and smeared because at the end of the day, 2 years ago, I knew what was going on. And each day that passes shows more and more that I was right. I understand that makes Karen Reed supporters angry, but the difference between Reed and myself is that I have the truth on my side. And always, I have never killed anyone. And she's like reposted one of her own shits here. And it says here, fun fact, this one almost slid by. Special Prosecutor Cosgrove has shed some light on the contents of Turtleboy's phones. Turns out Karen Reed, Boston defender Alan Jackson were all strategizing, leaking info, conspiring, and encouraging the abusive live streams. So, and what she did here was she posted like so ridiculous, dude. She posted Cosgrove's motion. Like, you know what I mean? Like that's fact. You know, as if it's fact. And it's right here. It says raising the objection inclusions of terms designed to screen out communication with Reed's defense attorneys on November 30th, 2024. Undersigned counsel has reviewed some of the data from one of two cell phones lawfully searched pursuant to warrant prior to any defense request for a taint team. It contends strength the Commonwealth's argument here. Carney's phone contains text message. It says test. Like, Jesus, it's like Plevin wrote this. Messages between not only the defendant and Karen Reed, but the defendant and attorney Yannetti and Jackson as well. The text exchanges also make clear that the Reed team was in telephonic and email communications. This email communication, the same people. It's, Jesus Christ, dude. Like, it's like Trooper Paul wrote this. The text exchanges also make clear the Reed team was in telephonic and email communication, the same people. That's what it says. The Reed team repeatedly provided Carney with information, including videos and copies of documents, sometimes with a request also acceded to that he not use it or use it yet, lest the Commonwealth discern its source. At times, they would suggest angles for Carney to cover or otherwise ask for his assistance. For example, on 8/8/23, Reed texted Carney, "Do you have the memo town employees were emailed about speaking to you reporters? Allen wants to blast it." The Reed team responded to Karen's specific request for information, discussed strategy, and quite frequently stoked his ego by infusing about his YouTube presentations. Carney reciprocated by passing along information he has come across, his own theories and the names and contact information of certain potential witnesses. Both the Reed team and Carney took pains to conceal their actual relationship. Jesus Christ. For example, on May 3rd, 2023, Yannetti texted Carney, "Dude, don't be offended if we don't shake your hand on the way into court. We want to maintain the separation and your independent investigation." So, so wait a second. Let me get this shit straight for a second because I'm tripping out. This is fucking hilarious to me, dude. I haven't even seen this shit yet. Okay. But this is really funny because it's so funny that Krusty Panties just said things like the truth being on her side as if it's fact, which is really funny. And that's what happened here. They stated something as if it was fact, even though it says the exact opposite, which is really, really, it's adorable, really. Like when you look, like, I'll repeat that last line here. Both the Reed team and Carney took pains to conceal their actual relationship. For example, on May 3rd, 2023, Yannetti texted Carney, "Dude, don't be offended if we don't shake your hand on the way to court. We want to maintain the separation and your independent investigation." Right. We want to maintain that. That means maintain. That means what is already existing, which is Carney's independent investigation. It is not an investigation fueled or sponsored by the Karen Reed team. That is nothing. It doesn't say that at all. It says we don't want to we don't want to fuck up your independent investigation. Like, to me, it's just like, if you don't see this as just being the same shit they pulled with Turtleboy when he first got charged. Those charging documents are full of shit like that. Like, full of all that shit. It's just hilarious to me, dude. An NH woman became a new member. I'm sorry, I forgot to acknowledge that. Thank you. So we're gonna go back to this stuff in just a bit. I just thought it was funny that Krusty Panties is Krusty Panties. You know, her being her. It's just very funny to me. It's my favorite thing in the world when people have these broad vocabularies, but are the stupidest fucking people you ever met in your life. And then they like wear the broad vocabulary as a mask to cover up their stupidity. And then it just gets nasty. You got Suzanne, excuse me, and Krusty just going at it here. It's just so ridiculous. All of this is so crazy that anybody. And then you got these Barstool Sports guys. I don't know much about it. I haven't listened to them yet. I don't really follow those guys. I know they got a lot of Twitter followers. But I don't know what their exact opinion is yet. I saw a few replies and tweets and things, and I don't want to take anything they said out of context and just take the masses' word for it. So oh, I gotta like that. That's good stuff. Yeah, this is just so funny to me, dude. All of this is just so silly. And the thing is I hate using that word to minimize it, silly. But that's what it is. Like, it's very serious in the sense that they're weaponizing the law to violate people's rights, turtle boys and Karens, just to start with. Not to mention everybody else's right to assembly and freedom of speech with this bullshit buffer zone. Not to mention all that. But those things are things that are very fucked up. But the insane tactics that are used are silly. And the justifications that are used are silly. It's just fucking wild, man. All right, let's watch this hearing, dude. And yes, I will be pausing it and interrupting and making fucking sound effect noises and all kinds of shit if I feel like it. Just letting you know. I want to hear any whining about it. All right, let me just do it this way. Here we go. Come on. Wow, this is a short hearing. The fuck?
Hey, Paul, I'm all set.
Just kind of weird. I mean, it's not weird because this is short notice. This was an emergency hearing.
Folks, make sure your cell phones are off and put away for me, please. Thank you.
All rise.
Judge, this is 22-117, and
So why is SD
23-3-1.
why is SD sitting on the O'Keefe side? I mean, she's obviously keeping her distance, but it's a little weird.
3, the Commonwealth versus Karen.
Being hell. Wow.
Oh, here we go.
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. Dad, 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 dad. I think we got a super dad.
How dare you?
Fair enough, Esty. Fair enough. Amy says, free my boy Billy Tibbetts. I love it. What's up, Amy? How you doing? What's up, Esty? How you doing?
Karen Reed, and separately the Commonwealth versus Aiden Q. Can I have the parties identify themselves?
Mr. Clerk, hold on just a moment, please.
Sure.
I need to plug in because I believe we have parties on Zoom.
Okay, I'm
And
sorry.
it's also my understanding that we're only here on case 0117.
That was also my understanding.
Okay.
Thank you.
And do you have the Zoom identification link for me, please?
I do. It's right here.
Thank you.
There's no passcode.
Thank you.
And listen, just to get a little off subject here, I want to address something before I forget. We're going to come back to this. It's not live, so calm down. So like, let me pull it up just so I don't misquote here. Because I want to address it. It affects the entire community to some degree. It's not that serious, but it affects the community to some degree. And so Mark Betterow, the mighty Mark Betterow, tweeted yesterday. And he says, just an FYI, after deep reflection, I have decided that I will no longer appear on streams that charge money for the privilege of hearing my opinion. And he put privilege in quotations. If I determine that I am willing to share my opinion without cost, I can't justify people paying money to hear my views. Sorry for any inconvenience, but that's my decision. And this is not, there's no reason to look. This is why I'm going over this real quick, because there's no reason to look so deeply into this. Okay. Just recently, Mazza made a somewhat similar announcement, and I think it's very clear what he says here. What he says here is that he's offering his opinion for no money. And seeing that people are super chatting, and this is a very common thing to do. I do this all the time, and I do this with not only Nan's blessing, but Nan's encouragement, is to highlight super chats that have questions. Because obviously, if somebody has a question and then they super chat, the creator is going to show the very minimum amount of gratitude that they can, highlight that question, highlight that super chat, because they paid for the question. To some degree, they paid for the question. Now, they are doing it to show support, but why not provide that supporter the perk of having their question highlighted and addressed? So that's why I do it. Now, Mark doesn't see any of that money. He's not complaining about not seeing any of that money. He just knows that there are people spending money that he knows their comments are going to be highlighted and addressed, and it's his insight that they're purchasing. To some degree, it's his insight that they're purchasing. He doesn't seem to feel comfortable with his insight being purchased monetarily, because he's offering it as a courtesy and as his contribution to the community and the movement. So that's what I got out of that. So I don't think there's any reason to look any deeper into that. I think that that's a very honorable, very respectable decision for the mighty Mark Betterow to make. And of course, he is always welcome here on this channel, and I am more than happy to circumvent any funds either just block them or circumvent them completely to Karen Reed, or well, it can't be Turtleboy's because he's on Turtleboy's team. So I'm sure that he would reject that as well. But I'm happy to just do it just to do it. You know what I mean? I was, and I felt, if I'm being honest, and I commented on someone's comment in one of those threads, and someone was like, well, you know, you creators, and I think they were addressing LTL, and they were like, you creators make money either way, just turning off super chats doesn't cut it, was basically their point. And that's true. When I do the 12-hour streams, what I'll do is I'll share my Venmo, and I will share the Karen Reed donation link. The only reason I share the Venmo is because people are like, Will, you're doing this for 12 hours. Let us buy you lunch. Let us send you something, you know, just to show our appreciation for you doing the 12-hour stream. And then I'm like, okay. But I turn off the super chats because I don't want people to get confused as to where their money's going. So I try to make the only link available to be directed to whatever fundraiser that I'm covering, which reminds me, I forget to do this sometimes. And so the way that I see it, I do this because I love it. You know, I'm lucky enough to where my channel has grown to the point to where I can do it pretty much full time. And I'm so grateful for that. But make no mistake that one of the things I'm most grateful for is that I can do this full time. You know what I mean? So like, and it's because I love it. So that's what makes it so great that I could do it full time. It's because I get to do something full time that I love. And so I know that I've, like, for the first couple of years that I had this channel, I wasn't monetized, even though I was eligible to be monetized pretty quickly. But for a while I was not monetized. And I was happy to do that. I had Colton Harris Moore on this channel several times. I didn't make a cent off of it. And it was just, I was grateful to be somebody that he felt comfortable talking to. This is a guy who didn't talk to the press. He's disappeared. He's off the grid. Nobody fucking knows where the fuck this guy is right now. And he's earned it. He deserves it. That's how he likes to live. I just hope he gets to fly a plane again one day. But and he's determined. He says he's one day, he says, I will fly again. Absolutely. But things like that made me love doing this. And the irony of it is, I don't even really like having guests on the show that much. You know, like I don't get me wrong. I do enjoy it. I like the streams that I do by myself more. I enjoy them more. Because I'm not constricted into a conversation. My ADHD can go wild and I can jump from thought to thought, and I don't have to get self-conscious about it as much as I would if I had somebody on here. I don't have to, you know, really focus, because if I have somebody up here, I have to really, really pay attention to what they're saying, because my mind can drift off and I won't fucking even know what the fuck they just said. It happens all the time. So to me, it becomes, it's so I not only do I not depend on guests for my content, I procrastinate and I put it off, you know. And it's not because I'm a dick. Like, I am a dick, but that has nothing to do with me being a dick. It's seriously because I just it's much of a less relaxed way to approach my content, is bouncing off of somebody. You don't know if you're going to have a good chemistry with them, and and it might make you look bad, or worse, it might make them look bad, and they were nice enough to be a guest on your show, and it's just a lot. These are the things you think about, or at least I think about, and it makes me fucking anxious, but I do love having guests on my show. I just honestly, I even toss around the idea of not doing it anymore, like, just because it's like, there's so much. Oh man, look at that.
Oh, here we go.
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. Dad, 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 dad. I think we got a super dad.
How dare you?
Great. Thanks, Will, for the great content. Thank you for the great content. Y'all need to sub to Microdots if you're not, and sub to his alt channel too. Microdots Clips. Richie's amazing. Thanks, buddy. So yeah, man. I mean, like, I get it. Like, it was weird. I actually felt weird taking money. That's why I wasn't monetized for the longest time. I felt weird about it. Like, it was other creators who started to like tell me, like, dude, why won't you like monetize your channel? It's weird. And I'd be like, I don't know. Like, this stuff really comes from the heart, and it feels weird getting paid for it. You know what I mean? And they would be like, yeah, but I mean, all the more reason, like, why not? What's the problem? And I'd be like, yeah, and I don't like people telling me what to do. So there'd be that subconsciously where I'm just kind of like, yeah, fuck you. And but I wouldn't say fuck you. They were just trying to help. And then there'd be like, but then supporters would be like, well, like, some of us prefer to show our support that way. Some of us hang out behind the scenes and we don't really comment. And we prefer to show our support that way. Some of us feel like this is our way to be to even show some sort of affection, appreciation, instead of just saying thank you. They don't think it cuts it. So they want to give some money because they have it and they want to. And I couldn't argue with that. I was like, fuck. I never looked at it that way. I never looked at it as like, to some of the supporters, you're inconveniencing them, because they really want to like show you support because they get something out of this that I still have a hard time imagining, but it's great. I'm really grateful. But the thing is this is why I totally understand where Mark's coming from. This is exactly why I totally understand where Mark's coming from. So it's not because of drama or any shit like that. Like, don't even, it's just Mark Bettero made a decision, and it's a very sound decision that absolutely tracks with his character. And Mark Bettero, I have grown to realize and learn, is a man of great character. So I absolutely respect his decision. I think we all should, and just and like, he has no reason to keep you guys in the dark of anything. He's stated it pretty clear as to what the decision was and why it was. So let's not worry about that too much. I'm sure we'll see Mark again on a channel, and there will be a way to do it. And and like I said, I'm happy to do it without making one red cent, because I just like talking to Mark, and I know you guys like hearing it.
Okay, Mr. Clerk, you may
Judge,
call the
thank
case
you.
and identify the parties.
22-117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Hank Brennan for the Commonwealth relative to docket 00117.
Good morning, Attorney Brennan.
Good morning, Your Honor. I'm Robert Cosgrove. I'm a special prosecutor on the Aiden Kearney cases, and I suppose for purposes of this motion, I'm the respondent to the Rule 17 motion.
Good morning, Attorney Cosgrove.
Good morning.
Hello, Your Honor. Timothy Bradel for Aiden Kearney. I see him on the Zoom for the record.
Good morning, Attorney Bradel. Good morning, Mr. Kearney.
And Mark Federer for Mr. Kearney. Good morning, Your Honor.
Good morning, Attorney Federer.
And good morning, Judge. Attorney David Yannetti for Karen Reed, who is also present on the Zoom.
Good morning, Attorney Yannetti. Good morning, Ms. Reed.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Attorney Little. Anyone else here that we need to recognize before we proceed? Doesn't seem so.
I mean,
Okay.
just the
Folks,
fact
we are
that this
here
happened,
on two related matters this morning. As an initial matter, we are here because
just the fact that this hearing is fucking happening seems ridiculous.
there seems to be some confusion concerning my order of March 20th on docket 615 on the Commonwealth's Rule 17 motion. Also, we're here because there has been a motion for protective order, docket 636, filed by intervener Kearney, and so we will.
Yeah, I got to agree with that, Scott. Just, if I'm being totally candid, I'm surprised Mark Betterow has done any shows since he started representing Turtleboy. I'm sure he knew what he was doing. I'm sure if he couldn't do it, then he wouldn't have. But, I was still, surprised that. But to me, that goes to his character. That goes to Mark Betterow's character is, okay, well, I could still do this. I just know what I can talk about and what I can't talk about. A lot of people will just be like, you know what? I'm not talking to anybody just to be safe. And that's perfectly sound. That's perfectly respectable. But, the fact that Mark Betterow still made the effort to contribute insight to this community is, it, like I said, it speaks to his character.
So with regard to my order, let me start by saying this. Going back to Attorney Brennan's affidavit filed in this case on March 5th, 2025, in support of the Commonwealth's motion for records, Attorney Brennan, you specifically stated that, quote, it's been represented to the court by defense counsel Bradel on behalf of Mr. Kearney that there's an implicit long-term mutual assistance and mutual defense agreement between counsel for Mr. Kearney and counsels for this defendant, Reed. On the basis of that sworn statement, I specifically inquired of you, Mr. Brennan, at the hearing on this matter last week, do any of the three categories of documents and data that the Commonwealth seeks by the Rule 17 motion include communications with Mr. Kearney and counsel for the defendant in this case? You replied, no, these would be privileged. So based on these representations and the court's belief that there were no privileged materials implicated by the Commonwealth's motion, I ordered that all communications between Mr. Kearney and Ms. Reed during the time frame in question with regard to these three articulated categories be produced. However, subsequently, the special prosecutor in Mr. Kearney's case, in possession of the documents in question on March 26, informed the court that, one, there are, in fact, a substantial number of communications within the documents and data requested that are indeed communications between Mr. Kearney and Ms. Reed's counsel. And moreover, the special assistant district attorney in that case took the position, contrary to the one asserted by Attorney Brennan in this case, claiming that those communications are not, in fact, privileged. So my order did not specifically exclude from production communications between Mr. Kearney and Ms. Reed's counsel because the court was told there were no such communications, and in any event, the Commonwealth acknowledged that they were privileged. So my first question is to you, Attorney Brennan. Respectfully, did I misunderstand you, or perhaps vice versa? In other words, I understood that you weren't requesting the production of any privileged communications to wit, communications between Mr. Kearney and Ms. Reed's counsel. And as such, if that is the case, and we did understand each other, I can simply clarify my order for special ADA Cosgrove that those claimed to be privileged communications will be excluded from the Rule 17 production, and we can move on. If that's not the case, I'd like to hear why.
Sure. Yeah.
Yes, you may.
This judge is fucking like he just came in and just John Wicked this whole thing. He just came in and just started like scissoring people's necks and then fucking shooting them in the head. And this shit was crazy.
I think there are two separate issues.
What's up,
regarding
Nan?
Privilege. One is whether Mr. Kearney's attorneys, Mr. Betterow and Mr. Brado, have privileged communications, and separately, Ms. Reed's attorneys' communications with Mr. Kearney.
Right.
Your Honor asked the question.
It tells you a lot because, like, I mean, I think it's safe to assume that this would have went a lot different if Bev was calling it.
I believe we were referring to Mr. Kearney's attorney. And so what I understood from the motion filings is that there were no privileged communications between Mr. Kearney and his attorney in those phones. And so there would be nothing privileged to protect.
Okay, I specifically asked, does this include communications between Mr. Kearney and counsel for the defendant, Reed?
I don't doubt that you asked that if that is what happened, but that wasn't my answer to the question because perhaps I was focused more on Mr. Kearney.
So you confirmed today that we misunderstood each other.
I love this. He's trying to play that word salad bullshit, and this judge isn't having it, dude. Let me fucking hear that shit one more time.
I specifically asked, does this include communications between Mr. Kearney and counsel for the defendant, Reed?
I don't doubt that you asked that if that is what happened. That wasn't my answer to the question because perhaps I was focused more on Mr. Kearney.
Okay, so let's break that down. I don't doubt that that's the question that you asked, Your Honor, but it wasn't the answer that I gave to that question. Brennan, Spanky, stop it. What the fuck was that? What the fuck was that? Dude, like this judge was like, what? One more time.
Does this include communications between Mr. Kearney and counsel for the defendant, Reed?
I don't doubt
My
that
favorite.
you asked that if that is what happened, but that wasn't my answer to the question because perhaps I was focused more on Mr. Kearney.
So you confirmed today that we misunderstood each other.
Or I misunderstood. I'll take responsibility for it. But I was trying to protect the attorney-client
This judge is awesome.
Mr. Kearney and his attorney, Mr. Brado, Mr. Betterow.
Okay,
I did
well, we
not-
all agreed, counsel, that those in fact would be privileged communications
course.
without question.
Of course.
So let's turn to, if you would, the second issue, which is one that you raised in your affidavit. You specifically raised that question in your affidavit, docket 547.
Undoubtedly. I do not believe there is
Undoubtedly.
any attorney-client privilege between Ms. Reed's lawyers and Mr. Kearney because those communications are not covered by attorney-client privilege because
Like what this seems like to me so far, people, what this seems like to me so far is Brennan really shat the bed when he tried to get the communications between Karen Reed and Yannetti. Like word got around about that shit. You know what I mean? Nobody likes this motherfucker now. This motherfucker totally blackballed himself and the whole legal community within his environment. What's up, Nurse Kim? Colleen R, thank you so much, member, for 3 months. Dude, like this judge is just like, bro, like you're really fucking around here, man. Like you're really playing roulette here, man. Like playing with people's privileged fucking communications between them and their lawyers, dude. The fuck is wrong with you?
Of Ms. Reed's lawyers are attorneys for Mr. Kearney. I pointed out that in an earlier hearing, and I have the transcript of it, it was December 17, 2024, when there was litigation in Mr. Kearney's case, docket 0313, that there was a position taken by Attorney Bradel. And he began by telling Judge Krupp, well, there's a joint defense issue, Your Honor. And Judge Krupp asked,
Thank you, Gaynor.
Any jeopardy to Mr. Kearney? And then Mr. Bradel responded, well, it's a little more complicated because we know he was under investigation along with Ms. Reed without any resultant charges, so we would contest.
Hold on. We gotta hold on 1 second here. 1 second. I gotta read this name properly.
Gay.
Nor Rands. Okay, there you go. Yes, I know. I know. I'm the king. I know. Let's get back to Spanky here.
Contend that does not fall under the umbrella. After more questions by the court, Mr. Bradel answered, we don't have an agreement, but there's been an ongoing long-term implicit mutual assistance and mutual defense that I myself have been part of for a long time, and Attorney Bedrow has as well. And Judge Krupp said, I really have no idea what that is. And so inevitably, there was no establishment of an attorney-client relationship.
Dude, I gotta know if him and Trooper Paul are related, bro. I gotta know
what that is. And so inevitably,
inevitably, Your Honor,
there was no establishment of an attorney-client relationship between the two. Inevitably, and after that, Attorney Bedrow attempted to file an appearance on behalf of Ms. Reed. And in that, there was a supplemental motion, and it's docket 549 on 0117.
And docket 549 contains Attorney Yannetti's sworn statement that there was no joint defense privilege between Ms. Reed and Mr. Kearney.
Exactly. And so I think I had the assumption there was no attorney-client privilege. If I misspoke, it confused the court. My apologies, but inevitably, there is.
You lied. You didn't misspeak. You lied.
And so I do not know what is in these phones. I have not asked. I don't want to know unless it's pursuant to a court order. But based on the affidavit of the search warrant and based on the pleadings in this case, and there's two very important pleadings, I may have mentioned them to the court on the last date. But those pleadings, which were filed publicly by the Commonwealth, and it's docket number 53 relative to Mr. Kearney's case 0043. In that pleading, it is set out by the Commonwealth pleading that there is, in fact, information demonstrating that the Reed team provided Mr. Kearney with information, documents, videos. It's suggested that at times they would suggest angles for him to use it or to refrain from using it. And it provides a number of examples, including an example on 8823, when they're asking for information, Mr. Kearney, so one of the attorneys.
Attorney Brennan, I'm going to ask you to pause right there because I think we've reached a point where I have a threshold issue that may require either a Bishop Franklin protocol or some inquiry into the nature of the privilege that may or may not be asserted by Attorney Bradel. And so I think.
Okay. Hold on. Brennan and Cosgrove tried to convince Judge that Karen used her attorneys as information mules to Turtleboy for him to intimidate witnesses. That's an outright lie in Bush League lawyering. Bush League. He's not a leaguer. He's a Massachusetts. He's not a leader. He's a Massachusetts leaguer. Karen used her attorneys as information mules to Turtleboy for him to intimidate witnesses. Yeah, I mean, that's insane. It's, yeah. Not only is it an outright lie, it is like fucking slander, dude. Swinging for the fence, got lucky with a strike. Turtleboy on third thinks he got a triple. Yes, Spiker Dots. Yes. Member for 11 months, Robin G. The judge spanking Spanky makes it a perfect Friday. Yes. Yes. It's wonderful. It's wonderful. And make sure to tune in tonight, folks, at 6 p.m. I'm going to have the Justice Serve TV crew, Linda and Michael. I'm stoked.
I think it's appropriate at this time, Attorney Bradel, that I turn to you, not with regard to the protective order, but with regard to the issue of whether your client claims a joint defense agreement and related privilege to communications between himself and attorneys for Ms. Reed, such that I need to limit the scope of my order of March 20th.
Judge, thank you. We do not assert such a privilege. I said in a much different context a long time ago that we had been sharing information and talking to each other and helping each other. And I said that there was an issue. I didn't say there was a privilege.
Okay.
So we are not asserting that. There is no formal agreement. There's no formal privilege. I said it was an issue to be looked at the time. That's all I said, Your Honor. And in terms of this, Your Honor's order, I don't even know why we're talking about this, Your Honor. The ostensible purpose of the Commonwealth's request was to attempt to show consciousness of guilt on the part of Ms. Reed. So why would communications to other parties besides Ms. Reed have any relevance? And in fact, in your order, you just say that the only communications that are on the table here, so to speak, are communications between Mr. Carney and Ms. Reed.
I'll stop you right
Nothing
there,
about
Attorney Bradel, because you
lawyers or
raised an excellent point, and that point being is that point from the court's perspective is in an age of group texts and other means of communications with multiple recipients at the same time, we certainly have the likelihood of communications between your client and Ms. Reed that may also include members of her defense team. So it is my belief that that is what might be at issue, but I will probe further of ADA Cosgrove on that point.
I mean, if you ask me, Your Honor, the pleading, that the impounded pleading filed by Mr. Cosgrove is completely immaterial. The whole reason for this is consciousness of guilt. So there are we're privy to these extractions. There's absolutely nothing in them that is covered by Your Honor's order. There's no communications between Mr. Carney and Ms. Reed regarding witness intimidation. There are none. So there should be exactly zero documents or texts or emails that should be responsive here. Absolutely zero. And I don't have the thumb drive that Mr. Cosgrove gave to the court ex parte. So I can only imagine what's in that. And we are anticipating a request that you will look at that, to ask you to look at that in camera and see if that complies with your order. It doesn't. It cannot comply with the order. Your order said Carney and Reed, not third parties that may or may not have spoken to Reed. And these are things that are.
So wait a second. So is Bradel's argument that the order says Carney, meaning Turtleboy, and Karen Reed, but since there's communication with David Yannetti, the order is not, it's pretty much void. I'm not sure if I'm understanding it. I'm just thinking out loud and wondering if anybody here is going to correct me. Like that's what I'm gathering is Tim Bradel's argument here. Right, Yannetti's out of the scope. Right. That's what I was thinking. Okay, so order says Turtleboy and Karen Reed only. Brennan not entitled to anything else. Okay, so yeah, it doesn't. Yeah, Brennan's not entitled to the communications between him and Yannetti. So it doesn't even matter that they fucking tried to use that shit. I mean, it doesn't even matter.
Privilege among that team. So this is a can of worms that the court did not open by any stretch. And I think that, you know, Mr. Cosgrove's role here is completely ministerial, Your Honor. And the fact that he's trying to jump outside of your order is incredibly inappropriate. In particular, because these two prosecutors are in different positions due to a conflict.
Like, I love this shit because everybody is now like, fuck this already. Like, these motherfuckers are dirty. And we're going to fucking go as far as we can to let the court know that we think that they're fucking dirty. I love this shit. Like, Bradle calling him out on that and being like, dude, the fact that he went completely out of the order is troubling. Like, you ordered him to do something and then he abused it. And here he is acting like, oh, well, we must have misunderstood each other, Your Honor. And for that, that's on me and I apologize. Bro, this judge is on to your bullshit, dude. Stop it. Kayla Jones, thank you so much. It's nice to see there are unbiased judges in Massachusetts. It is nice. It is nice. It's the second one I've seen.
Conflict of interest, an express conflict of interest that has been identified and supposedly acted on by District Attorney Michael Morrissey. So their communications need to be limited because there is a conflict. Your Honor limited those communications very appropriately to potential evidence that those two defendants could have communicated and in terms of some criminal acts. And we're telling you there's nothing there. We don't expect you to rely on our interpretation, but there is nothing there relative to your order.
Thank you. The fact that Attorney Brady, I'm gonna ask you to pause for a moment, and I'm gonna hear from Special Assistant District Attorney Cosgrove, specifically with regard to this issue. In your communication to the court, you suggested
No. Wait.
Production.
Wait.
A substantial number of communications between Mr. Kearney and Ms. Reed's attorneys. How would those be swept in when the order specifically calls for communications between Mr. Kearney and Ms. Reed?
I think the actions of Ms. Reed's attorneys on her behalf are the actions of Ms. Reed. And if one reads the sweep of the communications attorneys on her behalf,
Reed.
I think the actions of Ms. Reed's attorneys on her behalf are the actions of Ms. Reed. And if one reads the sweep of
Get the fuck out of my face. Of course that's going to be his argument. Of course his argument is going to be, well, since they're Karen Reed's attorneys, even though they're speaking to Aiden Kearney on their own, then they're speaking for Karen Reed. Like, since when? Like, I understand in a courtroom, sure. But, like, the cerebral ninja and the award-winning journalist can't fucking text each other and be like, what's that? They can't do that? They're not allowed to do that? Sorry, dude. If I can't give you a fucking fist bump in public, I don't want people fucking talking shit and saying shit that's not true. Like this. You know what I mean? Like, it's not even, this is all part of Spanky's MO, all part of Stiflin Spanky's MO is trying to railroad Karen Reed's defense. And he's doing it by fishing. It's ridiculous. He's been fishing. He's been doing it for months. Dude, I just sit there in the courtroom and listen to this asshole try to justify going into Bill Reed's phones. Come on, dude. Stop it.
of the communications between Mr. Yannetti and Mr. Kearney, and between Mr. Jackson and Mr. Kearney, and Ms. Reed and Mr. Kearney, one sees a pattern of feeding information to Mr. Kearney. I think that
Today, Junior.
together in that respect, Your Honor.
Thank you, Attorney Cosgrove. Notwithstanding that position.
Thank you, Attorney Cosgrove, for not dropping dead in my courtroom right there.
The court's position is that the order spoke very specifically and very clearly to limit the Rule 17 motion to the production of only.
Is the judge being passive aggressive, or is he doing this like unconsciously, where he's like talking really slow when addressing Cosgrove? Like, I can't tell if he's doing it to be passive aggressive, like to be a dick, or if he's like just subconsciously like, okay, you know how when you talk to when you're talking to somebody who doesn't speak English and you talk louder, would you like a bread pudding? Would you like, dude, she's Dominican, not deaf. You know what I mean? Like, I wonder if it's one of those things that the judge is dealing with right now. Like, he doesn't realize he's doing it. Like, it's great.
Thank you, Attorney Cosgrove. Notwithstanding that position, the court's position.
Like, he was fucking ripping through Brennan with a verbal Gatling gun, and when he's talking to Cosgrove, he slows it down by 50%, bro.
Is that the order spoke very specifically and very clearly to limit the Rule 17 motion to the production of only communications between Defendant Reed and Kearney and Defendant Kearney concerning those three areas of inquiry. So I am specifically requesting and ordering the Commonwealth in that case to review the documents called as a result of the Rule 17 motion in my subsequent order, such that the production will only include communications between Kearney and Reed.
Right.
Well, I will, of course, comply with Your Honor's order.
Thank you. Folks, I think we've covered that point, and I don't think I need to hear any further on this. The order is clear on its face, and I expect the parties to comply with it. I'd like to turn now to the issue of the motion at its face point. And
comply.
This is the best.
Well, I will, of course, comply with Your Honor's order.
Thank you. Folks, I think we've covered that point, and I don't think I need to hear any further on this.
Thank you. I'm trying to get the fuck out of here. Goodbye.
The order is clear on its face, and I expect the parties to comply with it. I'd like to turn now to the issue of the motion for protective order from Mr. Brado.
Like, that's it, homie. That's it.
You're entitled to shit.
You're entitled to shit.
So I'll hear you on this, appreciating that I have had the opportunity to review the attachments and certainly the basis for this. But I'm not, I'll preview where I end up, Attorney Brado. I'm not quite clear on the scope of your request as contained in your draft order. As an initial matter, I'm only issuing an order in the Reed case. This is not a hearing on the Kearney case. I appreciate that you have a congruent request to the court in the Kearney case, and that it may make sense that whatever the court does in that case should follow what the court does in this case. That would seem to make sense. But I'm only hearing the motion as it regards to this case.
Which is, yeah, I mean, that's perfectly reasonable. That's perfectly sound in my opinion. I mean, in this layman's opinion. And you know, but the cool thing about it is we still got to hear Bradel. You know, he still gave Bradel his piece. And Bradel did a great job, and all of that stuff's on the record. So that's fantastic. And like I was just hearing him go, it's not exactly it's not the Turtleboy case. But it's great that Bradel was there to represent Turtleboy, because he should. And he should be heard. But he didn't have to hear him, and it was really cool of him to do so. And it was great to hear Bradel give that argument as well.
Request, I'll note, asks that the court order all prosecutors and police in the above caption case to maintain the confidentiality of the cell phone data and any other investigative information and or discovery in each case. So I'm not prepared to discuss the entirety of investigative information and all discovery in this case. I am tasked with only addressing Mr. Kearney's specific cell phone data that is the subject of my order of March 20th. But you've specifically requested that the court order that police and prosecutors are ordered to refrain from sharing such information with particular parties identified in Mr. Kearney's affidavit and any other parties not part of the retained prosecution teams of Ms. Reed or Mr. Kearney. Aren't they already under a duty not to share such information with
yes, he did, Scott.
outside the bounds of what you request?
They are, Your Honor. Judge Cannone specifically found a substantial risk existed that any further communications about the evidence or the witnesses would jeopardize a fair trial. And she made that specific finding, and she imposed, I believe it's a 4-part gag order on the Reed attorneys. Nonetheless, as shown in my exhibits, Judge, these outside people are receiving information that in no way would a prosecution team ever share outside of anything ethically share anyway, any such information. And there's 3 examples of people who are, out there saying we've gotten this, we've gotten that. And we strongly believe that they are doing so. Just to avoid the slight awkwardness, Judge, of me arguing something that benefits Ms. Reed, I would invite, just for the record, the Reed counsel to join me in this motion, Judge, because of the leaks that are going on, just as a threshold matter, if I may do so, Your Honor.
Are you merely asking me to add a belt to Judge Cannone's suspenders?
I think so, Judge, because we need one, and we need one as to the specific information. These 3 people have repeatedly stated that they're privy to inside information, and with respect to Mr. Kearney's information, although we strongly contend there's nothing in there that is responsive to Your Honor's order, nothing. To the extent that there's anything that's shared between these 2 different prosecutors that are on separate islands due to a stated conflict of interest, we want to specifically ensure that as to the discovery that Your Honor's focused on here, that these orders are in place, that there's a specific order. It's sort of another step from Judge Cannone. She said that, well, the general rules of ethics aren't working here, so I'm making a specific finding. I'm giving you a gag order. Well, guess what? Judge Cannone's order didn't work either, based on my exhibits A, B, C. And so we're asking for another step to just really put a fine point on it, that these 3 people must stay away. And and a general order as well as part two is my part two. And to the extent that those people have any sort of further expressions of leaks in the media or on the internet, I think that ought to be grounds for a live hearing with sworn testimony about these.
Oh, thank you for the Venmo, Brenda. Appreciate it.
Leaks.
Understood. Okay.
So that's why I'm asking, Judge. Thank you.
Thank you, Attorney Brado. Attorney Little, Attorney Yannetti, do you have anything to add on this point?
We don't. I mean, I think that we generally take no position here. It is concerning to me that Special Assistant District Attorney Cosgrove revealed in a publicly filed motion communications with, or I should say between Mr. Kearney and counsel for the Reed team when the court's order was specific. My understanding is that he omitted.
I love how the camera is on Cosgrove while Yannetti is fucking smacking him up on top of his fucking bald head. He's like, this motherfucker, like, leaked that shit, man. That shit's not okay.
Some statements of caution and admonitions that we may have given to Mr. Kearney about the nature of demonstrations, etc. So it seems as though he cherry-picked statements in an effort to make us look bad when it was outside the court's order. It was unnecessary.
Attorney Yannetti, are you speaking to something that Attorney Cosgrove has purportedly done in this proceeding in the 117 matter?
No, in the fucking motion, bro.
No, I believe it's a motion that he filed in his prosecution. You know, again, detailed, you know, that material.
Thank you. Okay. Okay, folks, I will take that matter, the motion for protective order, under advisement, and will endeavor to respond to you as soon as practicable.
Yeah, agreed. Kindergarten Cop.
Decision on that.
For those of you who don't know, Kindergarten Cop is Scott, also known as the Potty Pooper.
88 Cosgrove, Special 88 Cosgrove, I'd ask you, how soon do you believe the Commonwealth can reproduce the records in question per my order that are called for by the Rule 17 motion?
Well, I would say we can probably extract from the thumb drive the conversations with Mr. Yannetti and Mr. Jackson. I may be able to get it done today. I think Monday would probably be a realistic filing date.
Thank you. We'll expect something by close of business Monday.
Right. And that just shows, Laferio, man, that just shows how fucking retarded Kate Peter is. Like this guy totally violated the judge's order, and Kate Peter blasted it thinking that it was like acting like it was fact, failing to realize that it really fucking all it did was just memorialize on the internet, where everything that hits it is forever. Memorialize that this guy fucking violated the court order and blasted all this bullshit out there. That's the kind of brains that the Karen is guilty crowd have.
If you encounter any difficulty or challenges in doing that, just please let the court know and we'll make whatever accommodations we need to make. Okay, folks.
Your Honor, is that thumb drive going to get returned to the Commonwealth?
Yes, it will.
All right, thank you.
And it has not been viewed, it has not been released, and it is being held under seal and impounded at the moment, and it will be returned to the Commonwealth promptly.
Thank you very much, Your Honor.
Attorney Brennan.
Your Honor, just for clarity of the record, I'll be brief. There has been no conversations between Special Prosecutor Cosgrove and I about contents of any of these items. In fact, even though I do not think I had to, that's why I filed a Rule 17, so there is a clear public record that we're beyond reproach. Secondly, the pleadings I referred to were pleadings that were filed in Mr. Kearney's case publicly before this issue even came up. So it is not divulging information to disseminate to the public. And finally, just so it's crystal clear, I filed a motion for a gag order in Ms. Reed's case because there was significant evidence of distributing protected materials, and that order was allowed at my request. There is no witness or person, as far as I know, in the Reed case that has disseminated any information improperly. I would not allow it or tolerate it if it happened. So I want that to be crystal clear based on the representations we just heard.
Understood. Thank you, Attorney Brennan. Thank you, Attorney Cosgrove. Thank you, counsel. No, we are adjourning the hearing now. Thank you, counsel.
Yeah, he's like, I got 9 holes.
Thank you.
I gotta go.
Thank you, Your Honor.
Thank you. Goodbye.
All right, so I've got some new motions here, and look at what happens here. This is interesting. Hey, what's up, buddy? How we doing? Isn't that Carl Dougal? So who was that? No, that's not Carl Dougal. That's what I thought. I wasn't sure. Who was that? John Jackson? I don't know who John Jackson is. The friend from college. Okay. Okay. No, I get names mixed up, man. Faces too. Like, yeah, Carl Dougal has like more of an asshole face than that guy and a fucking flat top. So I've got some new motions here. And here, I need to send another one to myself here because one of these is just fucking crazy. The defense filed a couple of motions, and so did the Commonwealth today. So, I think that's what I sent myself. Hold on a second here. All right. So this is the notice, and then I'm going to send something else here. Because that's not what I sent, but it relates. So so what I've got here is notice of reciprocal discovery regarding ARCO witnesses. Now this is the defendants. This is actually filed by the defense, actually. That's not what I wanted to go over yet. Let me try. I want to go over that afterwards. Okay. So Brennan is hell bent on this shit. Okay. So he's saying the Commonwealth's motion to compel reciprocal discovery of ARCO witnesses or to exclude their testimonies. The Commonwealth is seeking a viable remedy. The Commonwealth is seeking a viable remedy of the defendant's repeat Rule 14 violations and varying representations about the relationship between the defense and the ARCO witnesses. The Commonwealth does not believe that the defense has complied with Rule 14, nor the court-ordered discovery. The Commonwealth cannot wait until the middle of trial to properly prepare for the cross-examination of the defense experts. In addition, the defense's suggestion that it may request ARCA to conduct further review and/or testing would be in violation of March 6, 2025 reciprocal discovery deadline. 1 second, folks. Where was I? Therefore, the Commonwealth requests that the court order the defense to comply and certify its discovery obligations or exclude the ARCA witnesses. If the court is going to allow the ARCA witnesses to testify, what the Commonwealth requests is a hearing within 1 week to inquire of the witnesses about their past relationship and interaction with the defense to identify any materials the ARCA witnesses have received that are not listed in their report, and when they receive materials, and the basis for any opinions outside the 4 listed in their February 2024 report. In support of this motion, the Commonwealth states the following. In advance of the retrial, the Commonwealth began requesting discovery related to the ARCA witnesses on December 5th, 2024. Exhibit A. The court allowed the Commonwealth's motion to order the discovery based on the defense's repeated failures to produce discovery. The Commonwealth moved to exclude the ARCA witnesses in February 11th, 2024. The court recently denied the Commonwealth's request to exclude the ARCA witnesses. Now, this is interesting, because what's really happening here, what's really fucking happening here is that Brennan is just trying to be a dipshit. There is no there's no extra discovery. It's either that he's just being a dipshit for the sake of being a dipshit, because there's nothing to solidify any justification for what he's doing here. There's nothing. It's really ridiculous. They're saying, okay, well, you have all the shit we have. There's the 3,100 page TUI report. There's the flash drive with all the information on it. There's all the shit that the defense got from the federal investigation. The Commonwealth got too. So in the last hearing, not this one today, but the last hearing Tuesday, Alessi was up there I don't know what the fuck he's talking about. I don't have any fucking clue what this guy is talking about as far as discovery goes in regards to the ARCA witnesses. They have everything we have. So it's Brennan is just pretending he's making up this data and this evidence that doesn't exist, and he's claiming that it exists so that he can accuse them of not sharing it. It's the most fucking bizarre, blatantly crazy bullshit thing I've ever seen. And he's filing these motions. Look at this shit. At no point does he specify what he's looking for. He just calls it the appropriate discovery. The defense is contemplating the possibility of engaging the ARCA witnesses to provide additional opinions and conduct further testing and analysis. The defense's position that material ordered in Exhibit A are not within their custody and control, and therefore they cannot provide, is inadequate. Okay, stop. All right. And it says the defense must comply with the court's order for the defense to call the ARCA experts as witnesses. So he's sitting there saying he's trying to take them saying not within our custody and control. It's federal evidence, dude. It's federal evidence. And if it's not within their custody, then it's not within their control either. And if it's not in their control, then they can't provide it to you. You can fucking throw fits, throw yourself on the courtroom floor and start kicking and screaming like you've been doing. But you can't get something from someone that they don't have. It just doesn't work that way. It's impossible. It's physically impossible, Brennan. So this is his tactic. I mean, and that right there tells me that Brennan knows. Now, I'm not saying it tells me definitely. I'm not saying that, I'm saying that it tells me, or it indicates to me, that I need to keep a more open mind as far as the possibility of the federal investigation still being ongoing. Fact, the defense has never acknowledged that the federal investigation is over. Fact, only Helena Rafferty and Hank Brennan have publicly stated that they spoke to somebody from the state attorney's office or the U.S. attorney's office and claim that it was closed. These are facts. Now, knowing that, and Brennan going, no, that's not good enough. That's not good enough, Your Honor. I'm telling you that there's more information that they're not sharing with us. And he gave away what he was fishing for months ago. I don't have the document in front of me right now, but he straight up filed a motion compelling the court that they provide witnesses in the federal investigation, statements from witnesses in the federal investigation, stuff that there's no fucking way the defense is going to have access to. It's a federal investigation. So what it comes off like is Michael Morrissey is drunk on both fucking scotch and the obsession of wanting to know what he was being investigated for. That's what that indicates to me. Otherwise, why in the fuck would Brennan be doing this? Why in the fuck would Hank Brennan be fucking up his career like this? Because what he's doing is absolutely insane. Like he's acting like a total outlaw in the Wild Wild West. Like somebody who was, he's acting like Billy the Kid in the first Young Guns, right? They deputized him. They got warrants to go catch people, but he's like, nah, fuck that. And he just starts shooting motherfuckers. They killed my employer, Mr. John Tunstall. Yes, sir. Sheriff Brady. Like, took his badge and just started going nuts. That's what Brennan's acting like. It's crazy. Like, what do you mean? What in the, how you cannot be this desperate? There's no way that Hank Brennan would be so interested in that information. He has no stake in that. Morrissey is the one who needs that information. Morrissey is the one who's desperate to find out who the FBI has been talking to while he was being investigated. He's the master biter of all time. Sarah B. Creative, thank you so much. Yeah, this is just insane. So they don't even know. And now they don't want to be obvious in saying it. They're just saying the defense has information and we want it. They have evidence that they're not giving up, but they're not saying what it is. Oh, wait. I'm speaking too soon. Additionally, on March 20th, 2025, it was disclosed to the Commonwealth for the first time in an open court that Attorney Yannetti had received a federal subpoena from the United States Attorney's Office to produce his entire case file on March 25th, 2025. The defense further disclosed for the first time that the subpoena Attorney Yannetti was referring to was an ongoing federal subpoena. On March 25th, 2025, the Commonwealth was informed that discovery produced to the defense was in turn being provided to the United States Attorney's Office in an ongoing matter and included the entirety of the Commonwealth's discovery referenced in notices of discovery 1 through notice 57. The Commonwealth still seeks the following discovery: all bills, invoices, contracts, retainers, engagement letters, or payments that have been created for the defense of Karen Read or provided to or from the Read defense team from March 1st, 2024 to present. They already did that. All emails, letters, or any written correspondences, including text messages at any time between any employee of ARCA LLC and any member of the Read defense team, including Karen Read. You're never going to get that. You're never going to get that. So here he is trying to invade privacy here. Again, trying to just absolutely violate not only Karen Reed's rights, but the gentlemen who work for ARCA as well. Tried to violate their rights to privacy. Bev's never going to approve this. Even Bev is not going to approve this. Like, that is insane that he's asking for that. All phone ledgers evidencing phone calls or text messages between any employee of ARCA LLC, what? And any member of Reed defense team, including Karen Reed, at any time. At any time. All phone ledgers evidencing phone calls or text messages between any employee of ARCA and any member of the Reed team, including Karen Reed. What in the fuck does this? Who the fuck does this guy think he is, dude? All written communications or summary of oral communications between any employee of ARCA LLC and any member of the Reed defense team, including Karen Reed, relative to any facts, claims, documents produced, or any other information about the incident that is not listed in the February 2024 report. A written summary of all testing and findings that were conducted by ARCA employees Scott Klein, accident reconstructionist, and Jeremy Robbins, mechanical engineer. The source of all information about DNA and forensic evidence that was provided to Dr. Wolf and Dr. Rentschler prior to their trial testimonies. Jesus Christ. All data, photographs, videos of any testing, regardless of whether testing is the basis of any opinions. This request includes all data and memorialization of any field test. That is already included in the TUI report, dude. A copy of the, if it exists, it's in the TUI report. A copy of the federal subpoena received by the defense team referred to by Attorney Yannetti. An exact copy of all materials that the defendant provided to the United States Attorney's Office, including a list of content of all materials provided to the United States Attorney's Office, the date each submission was provided to the United States Attorney's Office. An exact copy of all materials that the defendant provided directly to any of the ARCA witnesses at any time. Jesus Christ. The defense's TUI request to the United States Attorney's Office following the United States March 4th, 2025 letter and any subsequent responses. If all of the request discovery is not provided to the Commonwealth or defense certification that each request has already been provided, the Commonwealth requests that the court exclude the ARCA witnesses. Now, sorry, I wasn't even paying attention to what I was reading right there because I was thinking about something completely different. I have to go back here. Something that I read that just hit me. On March 25th, 2025, the defense further disclosed for the first time that the subpoena Attorney Yannetti was referring to was an ongoing federal subpoena. Okay, so hold on here. Let me back up a little further. Yeah, so he received a federal subpoena from the United States Attorney's Office to produce his entire case file. This was March 20th. Okay? Now, somebody correct me. Okay? Because if I'm reading between the lines on that, y'all with me? If I'm reading between the lines on that, March 20th, Yannetti receives a subpoena. Yannetti, Karen Reed's defense attorney, receives a subpoena of his entire case file. A federal subpoena. A federal subpoena issued by the United States Attorney's Office. I'm seeing you guys in chatter with me. The case is still ongoing, people. Now, is the investigation over? Maybe. Like, are they done investigating Michael Morrissey? Yeah, but that doesn't mean that they're not moving forward with indictments. It doesn't mean that at all. Because it sounds to me like they're moving forward with something if they subpoenaed the cerebral ninja David Yannetti for his case file on March 20th, 2025. A week ago. Just over a week ago. So, yeah. And that would explain why Twitter's in a panic right now. Okay. Dolly Vision's here for the tight shirts. Free Karen Reed. I love it. Dolly's on board with free Karen Reed. Only took you long enough, buddy. But I think you're full of shit. So yeah, this is just absolutely fantastic. So yeah, I think it's fair. I think it's fair to conclude from that. And to conclude from the fact that the only two places we heard that this federal investigation was over. Now, somebody else did indicate to me, I'm not going to say who it was. I'm not going to say under the circumstances of which it happened. And I asked them straight up if the federal investigation was over. And they looked at me and went, that was their answer. So that's been what I've been letting go. But I don't know, dude. That tells me something else. That tells me something else. Why would David Yannetti receive a subpoena for his case file in the Karen Reed case on March 20th, issued by the United States Attorney's Office? Why would he receive that on March 20th, 2025, if the case is closed? It is not closed. Maybe the investigation has ceased, but it is not closed. Takes a lot to build a case, folks. An investigation is only part of it. So what I'm going to do is I'm going to read the defense's response to that. Notice of reciprocal discovery regarding ARCA witnesses, folks. Defendant hereby submits the following notice of reciprocal discovery regarding ARCA witnesses, Dr. Daniel Wolf and Dr. Andrew Rentschler. Request 1, a complete statement of all opinions to be expressed by Daniel Wolf and Andrew Rentschler and the basis and reasons for each opinion. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, voir dire testimony, and trial testimony of Dr. Wolf and Dr. Rentschler. Okay? Request 2, all notes, reports, and materials relied upon either witness for reviewing the specific case. Request for materials is not limited to the expert's report. The Commonwealth is requesting all materials relied upon in review, even if the materials are not part of the expert's report or opinion at trial. And the response that the defense gives here is the materials reviewed by Dr. Wolf and Dr. Rentschler were listed in ARCA's report. The United States Attorney's Office formally authorized the defense to independently retain ARCA and produce additional discovery to the experts for their review on March 26th, 2025. That same day, the defense provided additional materials to ARCA, including Welcher's reports for potential rebuttal testimony. All materials were immediately produced to the Commonwealth in reciprocal discovery. Okay, so what they're saying here is they're planning on bringing, they got the United States Attorney's Office, they got their permission to retain them as witnesses, right? They got the United States Attorney's Office's okay to do that. So that's on the up and up. That's already on the up and up. This bullshit that Brennan tried to pull, it doesn't fly, right? And so now, of course, the defense is going to watch their P's and Q's and make sure that they do everything, fucking cross every T and dot every I when they come with this, because they know that Brennan's looking to play dirty. He's looking to fucking squeeze nipples and kick nuts, you know? So what the defense is saying here is that they're asking for all these notes. So what the defense did was they contacted ARCA, and everything that was shared with ARCA, because you've got this guy, Dr. Welcher, You've got this guy who's going to try to go up against Dr. Wolf and Dr. Rechler. He's going to try to go up against these guys and try to discredit them on the stand. So the defense shared their reports, or at least the reports that that the Commonwealth shared with them. Those reports they're going to share with the ARCA experts. It's exactly what they're going to do. And so they shared the fact that they did this with the Commonwealth. This is part of that reciprocal discovery that they're talking about. So why are they saying that they are not getting reciprocal discovery when they're stating right here? It's filed. Commonwealth has everything that we have. Request 3, a copy of all materials provided to ARCA, Daniel Wolf, and Andrew Rechler, or any representative of the United States Attorney's Office by any member of the defense team by the United States Attorney's Office. The request includes all materials, including written, documentary, video, witness statements, and witness produced. Okay, so this is like all the video and shit that I said was probably already in the original 3,100-page TUI report. All materials, and this is what the defense says, all materials provided to ARCA by the defense have been produced in reciprocal discovery. A copy of the grand jury subpoena issued by the United States Attorney's Office to David Unetti, dated November 22nd, 2022, demanding production of all materials produced in discovery to date by the Commonwealth. All right. So I think I need to make a correction. So March 20th, 2025 is when the Commonwealth claims that they learned about this subpoena. This subpoena is dated November of 2022. So the federal investigation may not be ongoing. So a copy of the grand jury subpoena issued by the United States Attorney's Office to Attorney David Unetti, dated November 22nd, 2022, demanding production of all materials produced in discovery to date by the Commonwealth Karen Reed case, as well as all relevant investigative material was produced to the Commonwealth in reciprocal discovery. Pursuant to that subpoena, the defense produced that the discovery included in notice of discovery 1 through 47 to the United States Attorney's Office on October 22nd, 2024. The defense provided to the United States Attorney's Office with discovery relating to the vehicle reconstruction for the Department of Justice's determination regarding whether to provide this information in turn to the ARCA experts. The defense's understanding is that this information was not provided to ARCA, Dr. Wolf, and or Dr. Rechler by the United States Attorney's Office. Based on our best efforts and reasonable review of the files, all additional information relevant to this request that was produced to the United States Attorney's Office by the defense was provided to the Commonwealth in the federal materials both sides received from the federal government pursuant to our mutual TUI request in February of 2024. There it is. The defense's understanding that the only discovery materials produced to ARCA by the United States Attorney's Office were the materials listed in ARCA's report. That means that exactly what I said earlier, that they provided everything that the Commonwealth is asking for in the TUI report. Like they have the same shit that they have. Like they already have it. So they're compelling the court to make the defense produce materials that either they already have or don't exist, or the defense just doesn't have access to, because it is, according to the defense here, all the information that they have as far as the ARCA experts go is only related to their findings as far as what their studies were, what their experiments were, what their testing was in relation to, which is Karen Reed's vehicle and John O'Keefe's body. That's it. That's it. Nothing beyond that. So, again, Stiflin Spanky is fishing. And Bev should not be allowing this shit. Now, she's not going to, she's going to deny the motion again. And we know that. She's going to deny the motion again. But Stiflin Spanky just can't help himself. And then all materials provided to either witnesses after the conclusion of the defendant's first trial. All materials provided to Dr. Wolf and Dr. Rentschler after the conclusion of defendant's trials have been produced. Describe and produce any exhibits to be used as a summary, because that's the thing. Unless they could specify, like if Spanky can't specify what the defense is not sharing, and I mean specifically, like that's not going to cut it. You know, materials, that could be fucking anything. Video, recordings, reports. Okay, well, you have all that. But there's more. Okay, where are you getting that there's more? What makes you say that there's more? Produce this in your motion where there's more and what more that is. What is that more? Specifically, what is that more? And where is it coming from? So Spanky can't do that. So the defense is just simply doing this in writing, wasting more time and resources, having to answer to this bullshit and be like, we gave you everything. And then they have to list, we gave you everything. And then describe all compensation paid to either expert for all work done regarding this case, including the case preparation, testimony, travel, and expenses. And then their answer is the only funds paid to ARCA to date is the $27,606.41 detailed in the invoice previously produced to the Commonwealth in reciprocal discovery. On March 26, 2025, the defense retained ARCA for the second trial. A copy of that retainer agreement and rate sheet was produced to the Commonwealth. Provide any contracts, agreements, or documents relative to the Daniel Wolf, Andrew Rentschler, and ARCA LLC discussing compensation relative to this case. All information responsive to this request has been produced. And then again, with this all written communications, including emails and text messages between any member of the defense team and employees of ARCA. All information responsive to this request has been reproduced. Provide copies of all testing not previously disclosed, including crash test videos, reenactments, and any other testing materials and results, regardless of whether the witnesses or the witness will testify to the information at trial. All information in the possession, custody, and control of the defense has been produced. To the extent additional testing is conducted in furtherance of rebutting the testing conducted by Aperture LLC, that information will be produced forthwith. I mean, that's it. I mean, I don't need to go over the rest of that shit. That's it. You know what I mean? Like, you have everything. What the fuck are you talking about? So yeah, I would be shocked. Even though it's Bev, I would still be shocked if she were to not deny this motion for the second time. You guys want to snipe Court TV? let's let's do that. Let's do that.
In terms of alternative cakes for me, I don't eat too often
I
because
feel
I've been
bad.
stricken with type 1 diabetes.
All
But
I'm not gonna do that because I feel bad because they only have 400 people watching them right now. I feel bad because Court TV only has like 400 people watching right now. I'm not gonna snipe their stream. I'm even gonna give it a like. Let's do that. I'm gonna give it a like. Oh, that's awesome. And you know what? Brandy Churchwell, let me drop the link in here. This hasn't happened yet, but on the 31st, okay? Make sure to click on this and give it a like, and make sure to set the reminder for yourselves because Peter from The Lawyer You Know is going to be on Brandy Churchwell, man. That's awesome. 13th juror. Yeah, I honestly, guys, I think this would be a good time to call it. I think we went over everything I wanted to go over today. I'm gonna be on later. Hopefully I got enough time to go to the gym. Really hope I do. But make sure to tune in, folks. 6 p.m. I'll be live again, and I will have Justice Serve TV on with me. And I'm really excited about that. Really, really excited about that. So I'm gonna have them here 6 o'clock. No, that was Court TV. That was Court TV. I'm trying to tell you, it's Court TV. Look, I'll drop the link in chat. Vinny's private channel took over Court TV. It's right there. So, yeah, I think I'm going to call it, guys. So make sure come back 6 p.m. folks. Tonight, I will have Justice Surf TV on with me. I look forward to that because they are very, very interesting, and they're a couple of the good guys, and I really want to see their channel do well. So I'm going to get them up here and hopefully give their channel a little boost and expose how good they are to you guys who have not watched them yet. So, guys, I am going to go ahead and wrap this up. Thank you, guys. Make sure to hit the like for me. That really, really helps me out. If you haven't hit the like yet, make sure to remember to do that. And all the new subscribers, thank you so much. I hope you enjoy the channel moving forward. I really, really do. And thank you to you new subscribers as well. And if you're not subscribed, make sure to subscribe. Make sure to hit the notification bell so you get notifications when I'm going to go live. And all the support, I am so grateful to you guys. You guys are absolutely fantastic. I love you guys very, very, very much. And we will do this again very soon, my friends.